Section 29 subclause 3 of the Trademarks Act 1999, which talks about presumption. The court shall presume that it is likely to cause confusion on the part of the public. Shall presume word is used. Now the criteria are given in section 29 subclause 2c, which says that a mark is infringed by a person who is not a registered proprietor, who is not a permitted user, but that person is using an identical mark to the registered trademark. That means the infringer is using an identical trademark, the registered with that registered trademark. So both the marks, one who is using without permission, without consent, and one which is registered trademark, both should be identical. Second criteria is that person who is using without permission or without consent is using that identical mark for the same business or for the same goods or services. These are the two criteria. If the mark is not identical, then section 29 subclause 3 is not applicable. If the mark is deceptively similar, even though section 29 subclause 3 is not applicable. If the infringer is using the mark for different goods or services, even though section 29 subclause 3 is not applicable. Section 29 subclause 3 is only applicable whenever both the trademarks are identical and an infringer is using that identical trademark for an identical goods or service. Otherwise, section 29 subclause 3 is not applicable. Now I am talking about something in respect of shall presume. The shall presume, the term has not been defined under the Trademarks Act. Then how would the court presume? In that case, the definition of shall presume is given under section 4 of the Indian Evidence Act. I am reading that definition. Shall presume, whenever it is directed by this act means Indian Evidence Act, court shall presume a fact. It shall regard such fact as proved unless and until it is disproved. The term unless and until it is disproved plays very vital role because it indicates rebuttable presumption. So if the naturally shall presume, may presume, these two presumptions are always rebuttable. If that presumption is rebutted by the defendant or by any party of the case, then the court may think otherwise. And that is why unless and until it is disproved is mentioned in section 4. So section 4, we need to take the help of section 4 of the Indian Evidence Act in respect of considering the section 29 subclause 3 of the Trademarks Act, because no definition is given as far as shall presume is concerned in Trademarks Act. Friends, I hope you will like this video. I hope you enjoy this video. If you like this video, kindly share this video and please don't forget to subscribe my channel, and please press that bell icon, ting tong. Thank you very much.